Good afternoon. Nice to see everybody here. And we might create a worrying precedent by starting an academic meeting on time, as it's exactly 4 o'clock. But I'm really glad to see a lot of familiar faces and some new faces, and a real range from students, professors, members of the community, and colleagues from the UN. And so it's a real pleasure and honor to be here. My name is Matthew Gillett, for those who I haven't already met, and I work here at the Law School and the Human Rights Center. And today's event is going to culminate research that I've been conducting together with lecturer Dr. Sabina Garahan, who unfortunately couldn't be here today, and together with Kavita Mohanty, who's going to be speaking with us, and assisted by students of the Arbitrary Detention Redress Unit, of which we have 3 members in person, so Lily, Natalia, and Daniel. And then we have online Virginia, who's joining us because she did some research that's very relevant, and Maria has just arrived. So the topic today of migrants and refugees' rights is obviously something that's of significance legally, and that's, of course, my entry point, but it's also politically become a major topic. And we're going to hear about the number of elections in which this has been a major issue, and reflect on some of the human rights implications of this issue. I do have to pass on my thanks to the law school, my colleagues, especially Kat here for all the organization, and those who are involved in providing the grant that supported this work. It's really appreciated. And also note that here at the University of Essex, we have a Center for Migration Studies that does a lot of expert work on this topic. So there's quite a constellation of leading figures in this area. On the substance, I would at the outset say that it's been questioned by figures such as Austin whether international law is real. And he famously said, international law is not law properly so called. In recent decades, we've actually seen a flourishing of international law, and it's been applied both in practice and when it's been developed in theory. And we've seen, for instance, heads of state like Jean Kambanda from Rwanda, Slobodan Milosevic from the former Yugoslavia, detained, charged, and in some cases convicted of international crimes. We also see, for instance, civil aviation law applied thousands of times on a daily basis. So there is a real strong argument to say international law is not just real, but it's becoming increasingly prevalent and critical in our daily lives. When it comes to refugees and migrants, international law, in my opinion, is a natural fit because they inherently are crossing borders, inherently involves multiple states. And that's why I think it's particularly important for us to reflect on what are some of the key current challenges and future challenges that are coming down the pipeline. Of course, all persons who are in these circumstances crossing borders are humans and therefore have human rights. It shouldn't have to be repeated, but I think, unfortunately, it does have to be repeated sometimes. At the same time, there are over 190 states in the world, and there is a huge variety of cultures, legal systems, traditions. And so, of course, that generates questions as to how you formulate and apply international human rights law, particularly in relation to refugees and migrants. So I think there are challenges. There's a lot to explore academically and also for practitioners. And that's why I'm very glad that my colleague, Gehad Madi, the special rapporteur on the rights of migrants, agreed when I twisted his arm to come along to Essex. And I think we're very lucky to have him as the current special rapporteur on this issue, who is also a person who served 12 years on the Committee of the Rights of the Child, so the UN committee. And those issues obviously have quite a lot of overlap. And I certainly have some questions. If they're not asked, I will ask them after your presentation on this topic. He's also served on behalf of Egypt, his country, as ambassador to the UK and in various positions, and including as the Deputy Foreign Minister of the country. So we're glad to have brought you back to the UK, which you know very well. Unfortunately, the political circumstances haven't become less tumultuous than perhaps when you were here several years ago. but we are glad to have you here. And so with that, I will hand over to you and I'll introduce the subsequent speakers when their turn comes up. So thank you very much. Maybe we could give some applause to Gehad.
Good evening. Good evening, Professor, researchers, students, ladies and gentlemen. It is my great pleasure to come to Essex University and to address you on the issue of migration. And I'm very glad and thankful to my colleague, Matthew Gillett, for giving me this opportunity to come back to the UK. Well, in fact, I left UK on the Labour Party, and I come back on the Labour Party as well. I'm going to divide my speech into two parts. The first part will be on the policies of externalization. The second part will be on the status of migrants, particularly this year, where we are witnessing almost over 60 countries of political parties campaign where migrants are being framed in the political system of the campaigns, as we have witnessed lately in the results of the European Parliament. Well, it's a rise of the migrants. But first, on the issue of externalization. Framed as international cooperation or capacity building exercises with countries of origin or transit, realized through partnership or friendship treaties under the name of providing assistance to third countries, particularly in the area of migration governance. More and more states, as well as regions, make arrangements with third countries to externalize their migration and asylum measures, to process border and asylum procedures extraterritorial. This practice of externalization has become increasingly prevalent and draws serious human rights concerns. Border and asylum procedures, when externalized, negatively affect the human rights of migrants. Well demonstrated in case studies in the context of mixed migration movements. Migrants, including those intent to seek protection, are denied their rights to seek and enjoy asylum. They are either prevented from entering the territory of the state where they wish to seek protection, or their application considered inadmissible due to how they arrive and they are sent to third country without adequate safeguards to apply for asylum or await the outcome of return procedures. They are sent to third country, which they have no protection or relation whatsoever. Such practices exacerbate the situation of vulnerability and undermine procedural safeguards. In these processes, migrants, especially those with vulnerabilities, are exposed to human rights violation and abuse, including at the risk of refoulement or chain refoulement. Externalization has led to indefinite warehousing of asylum-seeking migrants in isolated immigration detention centers outside the territory of the destination states, exposing them to prolonged administrative detention, inadequate living conditions, obstacles in accessing justice and basic services, refoulement and other harms. The uncertainty and anxiety generated have caused severe harm to the mental health of the concerned individual. In addition to these direct negative impacts on the human rights of migrants, cooperation with states pursuing externalization strategies can also influence migration policies of enlisted third countries towards more restrictive approaches. Externalization strategy adopted by certain states and regions dehumanize and stigmatize migrants and refugees as unwanted. It fuels anti-migration attitudes, xenophobia, and racism. These extraterritorial actions are aimed at dissuading and preventing migrants, including those intent to seek asylum and protection, from setting foot on the territory or legal jurisdiction of the state or region concerned, or otherwise it would trigger protection obligation under international human rights and refugee laws. Well, as mentioned, one tactic used by state to externalize its protection obligation is making asylum applications legally impossible. Unlawful and incorrect application of safe third countries concept is often observed in such texts. Sure, in few models, states deem the first arrival state of transit country as safe third country, where the asylum-seeking migrants could be returned to after a superficial admissibility determination without conducting individualized assessment on protection claims of the applicants. Essentially, and sadly, through externalizations, countries pursuing such strategies attempt to avoid or limit their state obligations under international human rights and refugees law, and to externalize or shift such protection obligation to third countries, or in some cases, business enterprises, such as transportation companies. However, state may come to be responsible for human rights abuses outside of their own territory, as both states included in the process reaping joint responsibility. My mandate has been following and developing several externalization practices together with other international human rights mechanisms. We have been advising states against such plans and arrangements. Among these arrangements that we have been following closely, some good news came across. 2 weeks ago, the newly elected UK government announced to end the UK-Rwanda Asylum Partnership. I issued a press statement with several other international regional human rights mechanisms welcoming this decision. It was indeed a relief that 2 years after the initial announcement of this partnership, the UK government has finally made a courageous decision to abort the controversial plan, which would have externalized the UK asylum application and posed serious human rights risk for migrants, asylum seekers, and refugees. and would have also undermined the international protection system. There are more lessons to be learned for states to reflect on. Externalization practices are costly, both financially and reputational-wise. And these policies erode the human rights of migrants and tarnish states' human rights records. This was the first part of the speech. The second part, as I said, will be the status of migrants, particularly this year, where we have over 60 political elections in several countries, where migrant refugees are the scapegoat of political campaigns in this respect, as I said, as we have witnessed the results of the European Parliament election concerning the rise of the parties. A week ago, one candidate of the US presidential election announced, if elected, his first decision will be mass expulsion of migrants. So in general, this year will be very difficult for migrants, and as we witness every day with regard to the negative narrative against migrants by several politicians, using or abusing migration in their campaign. Unfortunately, such negative narrative are widely reflected by media, particularly social media, that is being functioned in the minds of people in that sense, forgetting or denying the contribution of migrants in many states around the world. Such a situation prompted me in preparing my first report to the Human Rights Council. I decided to highlight in my report the contribution of migrants in host countries, as well as in the countries of origin. If we look around, we will discover that migrants are contributing in every walk of life, in many states. And if I mention UK is a good example of this approach, where we see migrants and refugees have contributed vastly in every aspect in life here in the UK. From food, music, arts, sports, culture, politics, and economic, financial situation. I was talking to some British colleagues, and I was telling them, I lived in the UK for 8 years, and I noticed, as an example, the number of foreign doctors and nurses are more than the British doctors. If you look at the financial city in London, hundreds of thousands of foreigners are contributing to the economic situation, whether in high tech, whether in banking, in financial institutions. They pay taxes, employ more people, even lower skilled migrants are mainly doing the job that are being denied. So there is a need for such migrant approach where they contribute to the welfare of the country in general. We notice in Europe, in particular, there is a demographic problem with regard to the aging society in many countries of Europe, where there is a need to fill the gap of many jobs. So there is a need for more migrant to come and fill such a gap. My colleague, Matthew, mentioned that I was 12-year member of the UN Committee on the Child. 12 years made me, or made the rights of the child goes in my heart and soul. And then I decided also to make my second report to the General Assembly in October on the rights of my children. We witness in the world right now, there is over 300,000 detained migrant children in several countries. Some countries were replying to my letters in this respect, saying that, yes, sometimes we detain children, bearing in mind their best interest. I reply that detention of the children can never be in their best interest in any way whatsoever. Well, my report is sent yesterday to the editors, so it is finalized, and I'm going to present it in October this year to the General Assembly. Children are the most vulnerable. They are subjected to many severe abuses, same exploitation in all forms, including sexual exploitation, trafficking, disrespect. They are traumatized. Even some children are fleeing armed conflict areas, and they are severely traumatized when they enter the border of other states. Such a state is fully obliged to immediately protect them. It is under the Convention of the Right of the Child, Article 2, all states not to discriminate against children under their jurisdiction, which means when a child enters a territory of any state, he or she becomes immediately under the jurisdiction of the state, and the state is obliged to protect them. Yet, it's not happening in many states, as I said. It's almost almost 300,000 children. Disrespectful time without proper condition of detention, and in many cases without health, without education, and you need what form of abuse or abuse they are encountering. I don't want to take much of your time, yet it is my mandate to protect migrants and their rights, and of course, protect migrant children and vulnerable in the process of mixing migration. Thank you very much for your kind attention.
Thank you. And I think that's a critical note to pass the torch on to the next speakers who are not children, but what I've sort of termed emerging voices who have started to engage in research in this area, and I think have shown real dedication and great ability in this area. So we're really excited to have that, and obviously building on this huge amount of experience that we've heard you articulate, Gehad, which we really appreciate. So moving to Kavita, we'll say that she's an Indian qualified advocate who undertook her master's degree at a lesser known university called Cambridge, not too far from here, than Essex, and has previously worked on constitutional issues before the Bombay High Court, the Supreme Court of India, and refugee rights for an NGO in India, and is currently training to be a barrister in London as an Inner Temple scholar. So really glad to have you here and to hear about some of the research that you've been doing in this area. Thank you.
Good afternoon, everyone. I think when you go after an esteemed colleague like Mr. Gehad, you're at loss of words. I have to entertain you to make sure this is good. But first of all, thank you so much for being here. I think this reminds me of a tiny anecdote that my family has happened to live. When I was growing up in Dubai, we were immigrants, and my mom would always sleep with her passport under her pillow. And you know the reason for that? She was like, if there's a robbery or if there's anything or the police show up, we've not done anything, but I at least have our passports and we can go back to India. And at that point of time, I was barely 6, but I realized your passport is such a vital document for you to show your identity, because who are you without that? Our journey often starts with a strong feeling of home and belonging. Typically, it is tied to our place of birth, ancestry, or early childhood. However, as we navigate our life, we discover various places that we come to call as home. Thus, home isn't a fixed concept limited to our place of origin. For decades, migrants entering the UK, from the first generation of settlers to their British-born descendants, have found deep inspiration in their rich cultural, religious, and linguistic backgrounds. Historically, people have sought refuge in new homes due to urgent circumstances. More importantly, these departures are often dangerous and sudden. They leave little to no plan or time for you to think about, what am I supposed to carry with me when there's a conflict in my country? I just need to leave this place and find refuge in another country or anywhere else who are willing to accept me. Why do I speak of this? Firstly, the authorities that are concerned with the process of assessing asylum claims, they happen to vary by country to country. For instance, let's speak about where we are today. In the United Kingdom, the Home Office of United Kingdom Visas and Immigration, UKVI, I've had numerous encounters with them. They address asylum claims. They have certain caseworkers who initially process the application when you have a refugee at your doorstep. Let's put it as simple as that. And if you happen to have any appeals, they go to first tier tribunal and then an upper tier tribunal. There are many nations in the world who follow their domestic system to decide whether you're going to allow a refugee to stay in your country or not. While there are many countries like, say, for example, India, who have the UNHCR in place, High Commissioner for Refugees, who decide these cases. There's one thing that's common between all of the countries, is how do you determine whether I'm going to let this person be or stay in my country and that they're not a threat to my country? To set the context, the UK's approach to determining who is allowed to enter involves certain strict measures, if I were being polite. Under the Nationality and Borders Act of 2022 and the Illegal Migration Act of 2023, individuals arriving without proper documentation or thorough unauthorized means are criminalized and excluded from the asylum system. It sounds simple, yet it's not. This includes those arriving by small boats or hidden in lorries, as they can be dismissed as illegal entrants. However, we should not call them illegal, and we should call them irregular, if you may. Such individuals are perceived as attempting to bypass UK border controls and laws, thus criminalizing those in need of international protection. Now, this rings a bell. What is international protection? Because they're fleeing from their country of origin, where they face some sort of persecution, it is essential for us to decide in this country whether they can get international protection or not. And today my speech is all about fact-finding. How do you determine who needs that protection and who does not? Remember the passport story that I told you? What if people don't have that passport? How do you go about telling who you are and establishing your credibility? So in terms of administrative process, now you have caseworkers who assess such claims through interviews and documentation, and they use thorough fact-finding mechanisms to determine the credibility of international protection. On paper, this seems really simple, but in person, when you deal with people who have faced trauma, who may not be in a state to give you answers at that point of time and tell you what kind of trauma they faced, that puts them in this country and prolongs their asylum application process. Now, because I'm a law student, I'm going to give you a bit of case law, because what is a precedent? In 2024, which is a recent case law, and you might relate, is AB was the Secretary for the Home Department. The courts acknowledged the stark disparity, primarily based on nationality, between how Ukrainian and Afghan refugees are treated. They upheld the UK government's justification for this differential treatment on grounds of immigration control and national security. Thus, if the government is permitted by law to give refuge to one group while presenting another just as desperate with a closed door. My focus and my research with Dr. Gillett and Dr. Grahan has been on the potential fact-finding issues that happen. And in the beginning, I struggled to understand what kind of fact-finding issues at every stage of when you enter a country can you face. I will make it as simple as relatable it is for all of you. Firstly, if you come with your family, there's something called as verification of family ties. If you have somebody who's living in the UK, for example, you want to be able to establish a link with UK to show that A, you do need international protection. So asylum seekers who have family members already residing in a country where they seek asylum may need expedited processing to reunite with their loved ones. Family unity is a fundamental human right as declared by the UDHR. And prolonged separation can cause emotional distress and hardship, and that is not unknown to people. So potential fact-finding issues that occur in such situations is the verification of the claimed family relationship between the asylum seeker, which is the refugee, and the family members residing in the respective host countries. The second place where most refugees tend to stumble a lot is limited documentation. We're not unaware that in the world, there are so many wars that are happening as we speak. So there are destroyed or lost documents that refugees have to go through. Subsequently, there is limited access to documentation centers in many nations. And thirdly, there are lack of official records. For example, if people are fleeing in haste, they may not be able to collect identity documents before they leave, or they may lose their documents along dangerous routes to safety. For example, in Syria, we do see that the nature of displacement and breakdown of government infrastructure has caused a widespread damage to basic infrastructure of giving them documents. So most of the refugees who flee from Syria may not have a simple document like the way you and I have a passport or a BRP to show their nationality or their country of origin where they come from. Now, what this does is it puts them in the system, and while they're in the UK, they might have to go through immigration detention, which is not as rosy as the government might tell you it is. There's one aspect that I would like to highlight on, and as it was already pointed by Mr. Gehad as well, that the claims made by children, and the thing that children face the most is their age, especially the people who enter this country, say for instance, when they're 17. They claim they're 17, but they might be assessed as an adult, or they might be assessed as way lower, for example. So there are protracted delays, in fact, that other parts of the young person's life, most obviously in relation to asylum decision-making. This again causes excessive delay because the caseworker needs to determine what is the actual age of this person. Now, if the age of the claimant is material to the decision on the claim, then it's my opinion, and as it has been written by Amnesty as well, that the decision must be delayed whilst a full decision on their age remains outstanding. This is a heavily contested area that is being resolved. Now, my penultimate point is on the effects. As you might have imagined, these people have come to your country. Where do they live? Who is paying for their living circumstances? Are they even getting the education that they should be getting? So, for instance, with the Illegal Migration Act of 2023 in the UK, it was aimed at deterring irregular migration. But what this act has done is it has facilitated the detention of asylum seekers with minimum judicial oversight, leading to concerns about arbitrary detention, which is also similar to past practices in Australia. However, fortunately, Australian high courts have declared those practices as illegal. Now, additionally, the use of migrant hotels as a temporary housing, originally intended for short stays, often results in prolonged confinement, sometimes lasting months. The consequences of this are twofold. Firstly, it does restrict their movement and freedom, which is a potential violation of Article 12 of the ICCPR, which is your civil and political rights, which guarantees you right to liberty of movement and freedom to choose one's residence with the state. I can understand maybe to a point the government's notion of having these people in a particular facility for a time being. But what we lose to see is that there are certain barriers to employment. These people can't work. They cannot go to the schools that you and I go to. The fact that they cannot earn a particular amount, they cannot sustain their livelihood, which may potentially push them towards conducting illicit activities and then putting them from the immigration detention to the criminal detention, which is a very small gap for them. So the ramifications of such detention, albeit in migrant hotels where there are inadequate facilities, as we can understand, that has caused a lot of problems that these migrants tend to say. They already come from a conflict-ridden place, and over here they come for respite, but they're not given that. Finally, I would like to say that we have been talking a lot about the UK, but there are other nations as well where they have proposed an emergency law on the instrumentalization of migration. And I'm speaking of Finland, which aims to deter irregular migration by restricting asylum applications at certain border areas and permitting forceful prevention of entry. And that has sparked significant concern. This is as new as the last month could be. Amnesty International has stated that this law undermines access to asylum and breaches the non-refoulement principle. It risks violence and pushbacks at the border. The law allows exceptions, thankfully, for vulnerable individuals, but it does lack adequate time for proper assessment, and it provides no real appeal process, which is a nightmare for people. The lack of judicial oversight is something that is quite concerning. I thank you very much, and I think it is essential for all of us to keep in mind that albeit we are citizens, but somewhere out there, people are fighting for the basic rights, and we need to be able to voice and understand their concerns. Thank you very much.
Thank you so much, and for bringing that together. And I'll now turn to another student participant, Virginia Carnabuci, who is online and has been patiently waiting. And we're really glad to have you here. So Virginia is a University of Essex criminology graduate and a former member of the Arbitrary Detention Redress Unit, yay, here at the Human Rights Centre. She's currently a legal intern at the International Partnership for Human Rights in Brussels, where she's conducting research on human rights violations in Ukraine and Eastern Europe. So over to you, Virginia. We're in your hands. Thank you.
Thank you very much for your kind introduction and for having me here. I'm really sorry that I'm not there in person, but I'm happy we could find this solution. And I will be talking to you about the Memorandum of Understanding between Italy and Albania. This was signed in November 2023, and this MOU, Memorandum of Understanding, establishes that Albania will provide 2 portual areas to Italy and where 2 migration centers will be built. The plan is for Italy to rescue irregular migrants in international waters and to bring them to Albania. The first center will be built in Shëngjin, and this center will be for the disembarkment, identification, and first aid, and to provide first aid to irregular migrants, whereas the second center will be a bit further away in Gjader, and there Italian authorities will verify international protection claims and possible repatriations. Something important to highlight is that these irregular migrants will be in these Albanian centers. However, Italian law will apply to these centers, and irregular migrants will seek asylum to Italy and not to Albania. And this was just a quick overview of the Memorandum of Understanding, which became law in February 2024. The situation currently is that the building of these centers has been postponed. And I mean, hopefully I say like this because, well, I don't want these centers to actually work and come into place, but they should be operative at the end of this year. As you can imagine, there are some legal concerns by the international community and civil organization. One of the first concerns is the search and rescue operations standards that will be applied. So Italy has a duty to protect the right to life and physical integrity of those in danger at sea. Italy must make sure to bring people at danger at sea in a safe place as soon as reasonably practicable. It should minimize the time survivors spend on assisting ships and should make expedited arrangements to disembark people. Now, most search and rescue operations in the Mediterranean, they take place close to Libya, Tunisia, Malta, and Sicily. So the closest Italian harbors would be Catania, Messina, Lampedusa. However, these centers in Albania are located 1,000 kilometers away, meaning that survivors would have to endure at least 2 extra days of navigation. And as we've all said today, these irregular migrants, they're trying to flee in their country, fleeing prosecution. There might be people with vulnerabilities, and putting them through 2 extra days of navigation to reach these centers does not meet the search and rescue operation standards that have been set up. Another area of concern is the treatment of vulnerable people. And when I say vulnerable people, I mean pregnant women, unaccompanied minors, the elderly, people that have been subjected to torture and sexual violence. Before the signing, before this MOU became law in February, there were many reassurances from Italian authorities that vulnerable people would be excluded from this law, and that they would be brought to Italy and go through the regular procedures that are in Italy. However, there is no trace of this in the final law that was approved, meaning that we must assume that all sorts of irregular migrants rescued in international waters will be brought to Albania. And actually, Article 9 of this protocol that highlights how operations should take place in Albania, they actually mention cases of birth in these migration centers. So it seems that there was no real intention from the beginning to actually differentiate between vulnerable people and others to bring to Albania. And I think this point becomes even more concerning when we look at how automatic detention will be applied to everyone in these centers in Albania. So from the wording of the law, nobody will be allowed to get out of these migration centers. Albanian authorities will be involved to make sure that nobody gets into Albanian territory, because these migration centers, they are basically an extension of Italian territory, because Italian law will apply. Italian authorities will have basically control over the whole space and the people in these centers. And nobody will be allowed to leave these centers, and automatic detention for migration purposes, it's problematic in itself because there's no individual assessment of people's conditions, as well as the fact that we must assume that vulnerable people, including children, will be in these centers and they will not be allowed to leave under any condition. And another problematic point is that people will be allowed to stay in these centers for up to 28 days, which is the maximum time allowed by Italian law. And if somebody's application is not looked at, is not either confirmed or rejected within these 28 days, irregular migrants will have to be brought to Italy. However, if this was the case in Italy, people would just be released into Italian territory. If their asylum application would be accepted, people would just be released into Italy. But the same cannot be said if this would apply to Albania, because people will be transferred to Italy and they will have their liberty deprived beyond the 28 days established by the Italian law. And a final point, final problematic point, which is legal, but I would say also political, is the inapplicability of EU law. So Italian authorities have said, well, Italian law must follow European law, meaning that European law will apply to these centers in Albania. However, EU officials have said, well, European law is not applicable in Albania because it is not a member state, meaning that we will not be involved to check if European standards and European asylum law applies to these centers. And there has been a positive reaction, I would say, from European officials, but also other countries from this deal. There have been countries such as Germany, Austria, even Denmark, kind of praising Italy for thinking outside the box, finding a solution that externalizes migration processing, but kind of cleans it up from violating the refoulement principle. Because yes, Italy is bringing irregular migrants to a third country. However, it is not pushing the responsibility away to other countries, because irregular migrants will still seek asylum to Italy. Italy will have an overview of this. And because of this deal, many countries have had positive reactions, and they look at Italy as a model to follow. However, and this can be read as the symptom of how things are in Europe nowadays, with countries trying to find solutions and trying to externalize migration processing. And I think it is concerning, and the fact that there has been no attempt to stop this MOU, which effectively became law from February. So this is to kind of wrap up, and yes, this is the MOU between Italy and Albania. Thank you all so much for listening and for your time.
Yeah, thank you, Virginia. That's a really interesting example of quasi-externalization. I don't know if we'll categorize it as full externalization or not, so it will be interesting to hear the reflections. And I know that Gehad has issued a statement on the MOU as well, with contributions by Virginia. So it's great to see that working together. Now, next and last, but certainly not least, we have a fellow member of faculty here, Professor Geoff Gilbert, who, as the Sergio Vieira de Mello Professor of International Human Rights and Humanitarian Law, certainly has the coolest title in the law department, and has many other accolades. I'm not going to list them, But just to mention, he really is an expert on refugee rights, and he's been the editor-in-chief of the International Journal of Refugee Law for many years, on its advisory board, was the inaugural chair of the Global Academic Interdisciplinary Network, and has a really wealth of experience, both academically, but also advising the UN and other entities. He will offer some, I think, reflections on what we've heard and potentially some of his own thoughts. So over to you, Professor.
The name's Geoff. Thank you to Special Rapporteur Madi, to Ms Mohanty and Ms Carnabuci. Apologies for turning like that, but that's where you are as far as I'm concerned. I think the starting point has to be that states have the right to control their borders. International law says this. So it shouldn't be a surprise that they do it. And human rights treaty bodies have said, it's okay, this is what you're allowed to do. And this is against a backdrop of 117.3 million persons of concern to UNHCR at the end of 2023. And probably, because there's no precise definition of who is a person on the move, migrants, okay, close to 400 to 500 million people on the move, whether voluntarily or forced. You start thinking in those terms, think of the population of the planet, and immediately this is a large proportion of people moving at any one time across borders, within borders, and all at all stages having human rights. Their human rights do not end just because they go on the move. And I think this is a problem that we fragment our understanding of who are the humans, the human rights, as a way of limiting those rights. We put people in boxes, in silos. Are you a refugee? Are you an asylum seeker? Are you someone who is entitled to human rights guarantees against being sent back, who does not fall into the 1951 Convention definition? So all these matters, and some of them really are important. We've already heard about the distinction drawn within the European Union between Ukrainians on the one hand and everybody else who has been fleeing similar conflicts. And the only way to describe it is the typical racist approach of Europe. That is the only way. If you think that most people who cross borders, cross just one border, 76% of persons who are within UNHCR's mandate are in low or middle income countries, that despite the Global Compact on Refugees of 2018, which tried to create or put in writing that there is a responsibility on states to share the burden of forcibly displaced persons. And yet we see very, very little being done by states in the global north. This is the context in which we are trying to respond to a displacement crisis that is growing year by year. If you go back merely 10 years, we only had half the number of people we now have of concern to UNHCR. It's doubled in 10 years. And strangely, if you go back to 1990, it's the same 10 countries that produce most of the people who are within UNHCR's mandate. And they're crossing those same 10 borders and going into the same 10 low or middle income countries. So when you bring that context into account, what we've heard about externalization as a way of responding is truly contrary to what states agreed in 2018 at the United Nations General Assembly under the Global Compact on Refugees and the Global Compact on Safe, Orderly Migration, to properly share the burden of forced displacement. That's the starting point that I have whenever I am trying to look at how should we think about protection of people on the move. And I know, just to, anecdotes are always fun because they stop you having to listen for a moment and you can just go, oh, right, no, nothing to take down for a moment. But I was in an email conversation today with the chief of protection policy and legal advice within UNHCR, Madeleine Garland. And she was trying to answer something that I'd asked her to answer back in March. And she hasn't had time since March to answer that question. It's not that important. I can live without her answer. But that shows you the degree of difficulty, how many emergencies cross that desk every single day. And I have no idea what your inbox looks like, because it must be scary. Everybody praises Italy for this process whereby Italy will actually do its own processing. It might be in Albania, but it's doing its own processing. As though, just a minute, where did this fit into the protection regimes that have been put in place for over 70 years? It's almost as though if you're not doing something that's that bad, you're a good person. It's still bad, okay? And as already been mentioned, the PTSD of people who have been forcibly displaced is at a low, I mean, I have done status determinations, and you don't want to know what's hanging around in the back of my head. Okay. But when you've been through those experiences, the idea that you are locked up, the idea that you are detained and put in a place where you have no control, which is exactly what you may have been fleeing. That is wrong. And the 1951 Convention sets out in Article 31 that states do have the right to detain people who arrive, and the 51 Convention uses the term illegally. Okay. It's irregularly, but there you go. Enter the country illegally, but only for a short period, only while you determine what their status properly is, not indeterminately, because it's actually easier to keep them in a single place where you can control their movement. What comes across, and it came across in all of the presentations, okay, is just how much there are a group of people who are warehoused, put out of sight, and who are treated badly without nobody caring, because, trust me, they're not us. They're somebody else. We've put people in a box. Last story. Back to Matthew. During COVID, borders were closed. We all remember it. And by the way, I had COVID for the first time last week. I am clean, don't worry. I don't have to ring the bell anymore. Okay. But we closed borders. We even closed borders to asylum seekers. Some countries operated a quarantine system so as to make movement more threatening than staying in a country you were fleeing because of armed conflict. Some countries made it so bad for people who were forcibly displaced that they would prefer to go back to their country of nationality rather than stay at risk of COVID. And yet the right to health remains. It remains for those crossing borders and it remains for those within. And so if we're going, we've been really bad, really honestly bad about how Europe has responded. Can I say a small cheer for Portugal? Okay. Because during COVID, Portugal opened up its entire health provision, not just COVID responses, every part of its health service to everybody in the country, regardless of how they came into the country and why they came into it. Lots of countries said, yeah, don't worry, we'll inoculate you against COVID because that keeps us safe too. But Portugal, yes, which is not perfect in every possible way, but at least said, you know what, everybody deserves the right to health. And I think what we've heard from all the presentations today is everybody deserves their human rights, no matter what passport they managed to be carrying or didn't manage to pick up as they were fleeing.
Well, Kavita, you said big shoes to follow. I think there's 4 sets of big shoes to follow, and thank you so much for the really fantastic presentations that I think oriented around certain themes, but covered a lot of ground as well, and conveyed how many different types of challenges being faced in terms of youths, children, people having children whilst in these states of limbo, and the overlapping health issues that arise and probably will arise again.